breaking and entering, drunk and disorderly, law and order. A former prosecutor and a defence lawyer, not your typical pairing. And the result? Conversations about crime and punishment that are guaranteed to get you thinking.
Welcome to Justice Matters, a weekly podcast with Lizzie Green and Joe Crowley. Our episodes are available every Monday on Apple Podcasts, Spotify and YouTube. Follow us on Instagram and TikTok at Justice Matters Pod for clips. Enjoy the episode.
This episode contains descriptions of murder and murder of children, and Aboriginal and Torres Strait Islander listeners are advised that this episode also contains descriptions and names of people who have died. Listener discretion is advised.
Hello, Lizzie.
Hello, Joe.
Back for part 2 of our Bowraville murder episodes.
Yes, I did a big smile there, but that was to say hello to you, not about the murder case.
No, because it is a very troubling case.
Yeah, it is. It's one of those ones that when you read about it, you just can't let go of it. Like it really just sticks with you.
Yeah, not just for the senseless loss of young life, but also because there's not an insignificant dose of racism in this one.
And some legal bungling.
Legal bungling in police investigation bungling.
Yes.
So obviously we encourage people to listen to the first episode, but why don't I do a short recap?
How well were you listening to me?
I don't know. Yeah, you can give me a mark out of 10 in it. So in late 1990, so September 1990, young Indigenous girl called Colleen, 16 years old, young, vibrant, intelligent, goes to visit her relatives in Bowraville, mid-north coast of New South Wales, and is last seen leaving a party in, 17 September, something like that, in 1991.
Yes,
1990, sorry. Reported missing by her mother sort of a week later, and her mother, the police are very unhelpful in terms of that and investigating it. Then moved to, what are we in, February? No.
October
1990 again. A young 4-year-old Indigenous girl called Evelyn goes missing from her house in the middle of the night. Such a scary thing for parents.
Yes.
And is immediately the next day reported missing. And again, police do not act as one would hope that they would act in circumstances where a 4-year-old goes missing, and are very slow to do much about it. Then cut to February 1991, 4 months later, a young 16-year-old Indigenous boy, Clinton, he goes missing. He is staying in a caravan with a friend, 25-year-old friend, and Clinton's girlfriend, and the next morning, Clinton's girlfriend wakes up and he's not there, and he's never seen again. Well, sorry, he's never seen alive again.
Yes. His
body is found about a month later, and then not long after that, the body of Evelyn, the 4-year-old, is also found, and this is off a main road about 7 kilometres from the caravan park where they were staying.
Yes.
Both had died from some kind of head injury. But Colleen, the first one to go missing, body never found, but her clothes are found.
Yes.
Around about the same time. So this is about April 91.
Yes, that's right.
Her clothes are found. Now, a person who we can't name, so we're calling the person of interest for legal reasons, is arrested shortly after Clinton's remains are found and charged with Clinton's murder, subsequently charged with Evelyn's murder as well, put on trial for Clinton's murder with a view to later being tried for Evelyn's murder, but is acquitted of Clinton's murder, and the trial in relation to Evelyn is then withdrawn by the prosecution.
Yes.
But able to be brought again later.
Yes. Very good.
Oh, there you go. Thank you. And then, so we're picking it up now. So he is now acquitted, can't ever be tried again for Clinton's murder.
That's right. Because of double jeopardy laws.
But is suspected not only of Evelyn's, but also of Colleen's
disappearance
and death.
Yes.
Coronial inquest is that Colleen is definitely deceased.
Yes.
And then we moved to, I think we got to 97 or 98. The New South Wales Police do a re-investigation.
Yes, so there's a new strike force, and it is headed up by Gary Jubelin.
Oh, wow. Okay.
Yes.
A very famous podcaster now.
Very famous podcaster now, but back then, quite a renowned, tenacious
Thief taker. Can we call him that?
a thief taker.
Thief taker. That's from our
Bow Street Runner.
Bow Street Runner, yeah.
But a very tenacious investigator who really worked very hard on the cases he was involved in. And we'll talk about Gary Jubelin a bit more as to what he's doing now.
Yeah.
But he was heading up that investigation. And so as a result of that reinvestigation, there was some progress made, enough so that there was a second coronial inquest.
Into whose death?
Evelyn and Colleen.
Okay, so we have done a whole episode on coronial inquest, but so if there's a suspicious death, the coroner is obliged legally to investigate. Often, what happens when the police have found somebody and charged them is that the coronial inquest sort of waits until the trial. But in circumstances where we've had a trial and the guy's been acquitted, and then the coroner does a further inquest.
I think it was also to do with police processes. Because remember we talked about coronial inquests can be used to identify flaws in processes and to make recommendations for better practices and that sort of thing.
Yes.
So I think it maybe had to do with the initial investigation and response to the disappearances.
Yes.
But so this is now February 2004.
Wow, that's a long time later. So 14 years later.
Yes, 7 years after the strike force was established. We're now at the point of a second coronial inquest into Evelyn and Colleen's deaths.
Yes.
To date, that is the only official proceeding in which the substantial tendency and coincidence evidence that had been uncovered during the investigations was able to be heard all at once.
Okay. So that is what we've been terming similar fact evidence, isn't it?
Yes.
And we actually did a whole episode on it, didn't we?
We did.
And so the reason it can go in a coronial court is because they've got totally different rules of evidence.
That's right.
And it's a more inquisitorial. So the coroner can hear all of the evidence about Colleen, all of the evidence about Evelyn, and all of the connection between the person of interest and both of them.
And even Clinton's
matter
was brought in as well.
Brought in as well.
Yes.
Okay.
All right. So the coroner handed down his findings in September, so some 7 months later.
Yeah, September 04.
Yes.
Okay.
And found in relation to Evelyn that the inquest should be terminated because he was satisfied there was evidence capable of satisfying a reasonable jury properly instructed of her murder, and there was a reasonable prospect that the jury would convict a known person of her murder.
Yes. Okay. So the coroner, it can only make recommendations.
That's right.
And so is it recommended that a person known to the police or whatever they say
be prosecuted? Correct.
Okay. And do they prosecute?
Hold on. Oh, in relation to Colleen, the coroner determined that she had died of a homicide, but that the murderer could not be identified on the evidence presented.
Interesting.
However, the coroner went on to note that, like the investigating police, he was of the opinion that the circumstances surrounding the three deaths had strikingly similar characteristics.
Yes.
And the coincidence and tendency evidence presented suggested that the person of interest had been involved in Colleen's disappearance.
Yeah. Okay, so just to quickly recap that, so Colleen, the 16-year-old who first goes missing in September, she knew and had stayed at the caravan of the person of interest, and she had made complaints that the person of interest had sort of interfered with her while she was asleep, I think. And her jeans are found in the river, and then later a bag that's weighted down, it has the rest of her clothes in it.
Or other clothes.
In it.
Yes.
Yeah. So it's not the case that she could have walked along the river and fallen in and drowned.
No.
It was clearly something.
Some foul play.
Yes.
Yes.
Okay.
So on terminating the inquest, the coroner advised he would forward the evidence and his recommendations to the DPP.
Yes.
Would urge the DPP to look beyond the factual matrix as it relates to the murder of Evelyn Greenup, and to look closely at the tendency and coincidence evidence in relation to the matters of Clinton and also Colleen.
Okay, what an interesting way to phrase it. So the DPP are then being encouraged to prosecute the person of interest in relation to Evelyn, which they can do because they didn't proceed with their earlier prosecution.
Yes.
But they're being asked to look beyond the evidentiary matrix, and that sounds weird.
Yeah.
What are they looking into a crystal ball? I mean,
All right.
just go on the vibe, prosecutor.
Okay. So then what happened? We did have an ex officio indictment filed against the person of interest
Yes.
by the New South Wales DPP
Yes.
in relation to Evelyn.
Yes.
And that trial commenced on the 6th of February 2006.
Okay.
No charges were laid in relation to Colleen.
No. But again, the coroner had decided that there was insufficient to
Yes,
charge.
that's
and
right.
that's the coroner using all of their amazing abilities to get in lots of evidence
That's
which
right.
wouldn't be admissible in
Yeah.
a trial. So the coroner says probably shouldn't prosecute. I suspect that's pretty.
So we're now in 2006, and in that time, the Evidence Act of New South Wales, or the Evidence Act, was amended, and the rule about similar fact evidence was introduced in a different form to the no rational
Yes.
explanation.
Yeah.
Is that
Sorry.
what it
Yeah,
was?
that's yes. And sorry. I probably only for the lawyers, but let me just say. So we talked about Fennigan, which is the High Court's decision in terms of similar fact evidence, but statutes always trump common law. So that in the Evidence Act in New South Wales, which I just want to put on record is a horrible act.
Oh, is it?
I hate it. It's just revolting. Luckily, I almost never have to deal with it. They then put in a test. They can put in a test themselves in relation to what we would call similar fact evidence, and they then fiddle with it, which is always a problem with legislation, to, I don't know, probably make it more confusing.
So what I saw was that 2 years after the original trial, the no rational view test was replaced with a discretionary balancing test.
Right.
In terms of whether or not to allow, so that balancing of probative versus prejudicial value.
Yes.
And the law and coincidence evidence broadened again with the Evidence Amendment Act 2007. Well, that was too late for this 2006 trial.
Yeah.
But so it was a different test now.
Different test. Making it easier or harder?
Well, you would have thought maybe it would be a more favourable test for the prosecution. I'm always thinking in terms of the prosecution.
God. Okay, well, that's usually what legislation does, but it's not what it should do,
but the court found it still prevented certain evidence regarding the person of interest's previous behaviour from being admitted at Evelyn's trial.
Yeah.
And also evidence relating to Clinton's murder was inadmissible because of the laws of double jeopardy.
Yeah, so he's been acquitted of that, so you can't then effectively de facto accuse him of the murder in another trial.
That's right, because it's in order to have that put before the court, you're effectively saying he was guilty.
Yes.
And he's been found innocent.
Yes.
Much of the evidence relating to to Evelyn's death was considered solo, in the absence of any context or understanding of other crimes.
Yes, that is how most trials work. Yes, you just focus on the evidence in relation to whatever the person, the
and
victim. Yes.
He was acquitted.
Okay,
so 2 acquittals.
He's winning Clinton 2-0 at the moment.
And Evelyn's matters.
Right.
So that seemed to be the end of it for a little while.
Yes.
But we still have no knowledge of what's happened to Colleen. Her body has still never been found. The families are still searching for answers. Gary Jubilin was now very invested in this matter and was, I suppose, dissatisfied with the progress through the courts.
Yes.
And as a result of a number of different things, there ended up being a parliamentary inquiry in 2014.
Okay, that's interesting.
Yes. And so that revealed, among other things, I'll talk about them, but that revealed that the prosecutor who ran this 2006 trial had made comments to the police before the trial started that he'd already formed the view that the case would fail.
Wow.
Yes. And that was corroborated by another former prosecutor who worked at the DPP at the time of Evelyn's trial. He didn't run it.
Sure.
And he said, I had the view at the time that if the matter was to run to trial, it was being run as a trial because it was one of those trials that you had to run, not a trial where a conviction was, would be well justified.
Okay, well, I don't think there's anything earth-shattering in that. Obviously, as a lawyer, you form an opinion of the strength of the case that you're about to run. I've run trials that I thought were not going to win.
Not as a prosecutor, though. You're meant to run a prosecution if you have a belief that you will have reasonable prospects for conviction.
Reasonable, yes. Well, it mightn't be that the person running it. I mean, the DPP might say, I think it's got reasonable prospects, you run it. And the person who's running it says, I don't think it does, but I've been told to run it.
So what I think the inference we're meant to draw here is that they ran the trial to keep people happy.
Well, I think we all know that happens all the time.
But it doesn't make it right.
Sure.
And when you think about the time invested by the families and the hope that they felt, and they talked about it publicly, about going to court every day and feeling such hope that there would be justice, and then being attacked by the media. Well, how do you feel now that he's been acquitted? You know, the mother, I think, collapsed.
Yeah.
In the onslaught of the media attention. You know,
Sure.
So all of that, to run a trial you don't have faith in, I think that is
only if it affects his performance. I mean, he might be a very good actor and get out there and
maybe
run it brilliantly, despite his personal beliefs. I mean, you are, as a lawyer, supposed to be, you know, your personal opinions about witnesses.
I know, but you're also, anyway, that was just one thing that came out. Another thing, beyond the fact that this family were attacked by the media.
When you say attacked,
no, sorry.
Okay, so they're approached by the media.
Hounded by the media.
I mean, the media, you know, it's a high-profile case. They're going to ask questions. I mean, that's not a particularly invasive question. It's pretty obvious one.
My point was to be going through all of that if the prosecution never had faith in it in the first place. It's a lot of emotional trauma and angst if there was no real prospects. You know what I mean?
Sure.
Anyway.
Again, this is a very bizarre place for me to be because now I'm defending the prosecutor. But, I mean, you know, the family had their day in court. They, as the victims, you know, they could see the matter prosecuted.
I know, but
they didn't get the result they wanted. Okay, that's very disappointing. I appreciate that. And obviously it's difficult to deal with the media. We've talked a lot about media on this podcast. I appreciate that, and that's difficult for them. I understand that. But are they honestly saying they prefer not to have their day in court?
No, I'm not saying that. I'm just saying it's an interesting insight that the prosecutor who ran the case had no confidence in a conviction. The other thing that the family felt upset about was that on the day of the verdict, they brought riot police in and they apparently took up the first 2 rows of the courtroom, which meant some of the family, so Clinton's dad in particular, couldn't get a seat in the courtroom.
That sounds ridiculous. Where was this being tried? In like Lismore or something?
Well, now you're asking me questions. I don't know. But they said it gave the impression that the police thought the community was the problem, that there was going to be riots, and there'd been no suggestion of that at all. So that was, you know, another thing that they were contending with.
Yeah.
And so then it was an acquittal. So now we've got 2 acquittals, double jeopardy exists, and still no closure or understanding of what happened to Colleen.
Yes. This does have parallels to the Deirdre Kennedy case.
It does. And in fact, Bowraville, this case, and Carroll.
Carroll was the man who was charged and acquitted twice of Deirdre Kennedy's murder.
That's right. Were both cited by Queensland and New South Wales when double jeopardy reform was being pushed. Yeah. So these were the 2 landmark cases where the need for reform was highlighted.
Yes.
So Gary Jubelin had worked really closely with the families.
Yes.
And it took some time. They were very skeptical of him at the start.
Okay.
But he earned their trust.
Yes.
He demonstrated his, you know, real investment in the case.
Yes.
And so he actually became sort of an advocate for the families.
Okay.
Despite being a police officer, you know, he was also working with them to push for legislative change in relation to the double jeopardy laws.
Which is only going to help if new and fresh and compelling evidence comes to light.
I know. Wait till we get to that.
Okay.
So he had worked really hard trying to find new evidence. He, you know, did look at that person of interest, but he struggled to find anything new that would further the case.
Yeah.
When he was interviewed by that parliamentary inquiry, he said, I feel that I'm well placed to say that the families have been let down by the justice system.
Yes.
Given the situation that the families found themselves in, it would be reasonable for them to assume that the authorities would provide a suitable response to a serial killer preying on the community.
Yeah.
Unfortunately, that was not provided. It is very nice for society to say that all victims are treated equally. Unfortunately, in this situation, I do not think that is entirely correct.
No.
So that was quite a big statement.
Absolutely.
For a police officer,
Yeah.
particularly to say.
Yeah.
Then 2006, New South Wales reformed their double jeopardy laws,
Yep.
which we're familiar with how it looks now. You can retry in limited circumstances.
Yes.
You just said fresh and compelling, and
yes.
if it's in the interests of justice.
Yes. So we talk about this in our Deirdre Kennedy
Yes.
podcast. Yes. Okay.
Raymond Carroll.
Was that a two-parter? I think it was. Yeah, it was a great one. Yeah.
And so I guess because the Bowraville murders had been flagged as one of the impetus behind the legislative reform, there was, again, a lot of hope raised within the families that this would lead to some real outcomes for the cases of their children. I did find a little quote I really liked from Lord Justice Robin Auld, a UK justice from 2001, where the concerns about double jeopardy being reformed, he summed them up. It was a review of the UK criminal courts. And he said, if there is compelling evidence that an acquitted person is after all guilty of a serious offence, then subject to stringent safeguards, what basis in logic or justice can there be for preventing proof of that criminality? And I think that is the essence of the reform. Like if you have good reason to suspect a wrongful acquittal, then it's just as worthy of being investigated as a wrongful conviction. So I liked that.
Sure. One of the problems that I have is that, you have a case where things are investigated really badly, and because of that, or probably because of that, a guilty person is then acquitted, and then there's complaints and legislative reform. It's like, well, here's an idea. It's an opportunity cost to the system that sometimes, you're not going to get the conviction you want, but, maybe you should make sure police are doing their job more rather than go through legislative reform. I think that's the argument. I can't remember in the Deirdre Kennedy case it was badly investigated, but
well, there were problems.
There were problems in the investigation. No, that dental evidence which we talked about is terrible.
Let's not get onto the dentist.
Okay, so so that there's that old saying: bad cases make bad law. Just because you have two extreme cases where it looks like a guilty person has been acquitted, do we really need to have legislation? It's just an opportunity cost in the system.
And do you know what though? So I mean, we talk about the difficulty in a wrongly convicted person appealing because they also have to meet that threshold of new and fresh evidence.
Oh, don't even start me on that.
I know. So I'm going to give a shout out to one of my students who's writing a 8,000 word paper, Matthew, at the moment on this. Yeah. And that interpretation of fresh and new is so fraught with complications and inconsistencies. Well, the double jeopardy laws, based on fresh and new evidence, they're yet to be properly tested. Like the number of cases that have failed to satisfy that threshold.
In terms of a re-prosecution.
That's right. So you kind of wonder, well, what's the point?
Yeah.
But anyway, so because there was this reform, the strike force forwarded a submission to the DPP to seek a direction as to the sufficiency of fresh and compelling evidence to warrant a retrial for the murders of Clinton, Evelyn, and present an ex officio indictment in relation to Colleen.
Wow, okay.
Yes, so they're trying to bring all three of them back before the court.
Okay.
So in June 2007, the then Director of Public Prosecutions, Nicholas Cowdery,
I'm a big fan of Nicholas Cowdery, but you don't like him.
Not one of my faves.
No? Okay.
He advised the New South Wales Police Force that having considered the material carefully, in his view, there was not fresh and compelling evidence, and so declined to put in an application.
Yeah. You don't like him because of his decisions in the Folbig case, was it?
Not just Folbig, but Kelly Lane.
Again, these are two cases we've done podcasts on.
And Lynette Dawson.
Lynette Dawson, that's right. Oh.
He just, I think, was a bit of the old boys club.
Wow, okay. Maybe that's why I
don't
like
know
him.
him personally at all.
No.
Don't say that, Joe. Okay, so following that rejection, a senior counsel, Chris Barry, actually provided the families with an independent legal assessment of the matter and concluded there was sufficient evidence to justify an application to the Court of Criminal Appeal for a retrial.
Wow.
He expressed his expert opinion that should the matter go to trial, there would be a reasonable prospect that a jury would convict.
Okay.
So between 2010 and 2013, the families, with the assistance of lawyers, made 2 submissions to request that the Attorney General use his discretion to apply to the Court of Criminal Appeal for a retrial.
So I'll just explain that. So the DPP, the Director of Public Prosecutions, is and his or her office is separate to, although a government organisation, it's completely independent of government. But the Attorney General, who is a Member of Parliament, and the Chief Law Officer retains their own power to prosecute, so they can. When the DPP doesn't want to prosecute, the AG can then prosecute. Yeah.
So the first submission was sent to Attorney General John Hatzis, I don't know how to say his last name, but in 2010, the second to Attorney General Greg Smith in 2011, and both requests were refused.
Yes, okay.
After the first application for a retrial was submitted to the DPP, the families became aware that the review of the matter was being undertaken by the same prosecutor who had run the prosecution of Evelyn.
Wow.
Yes. And one of the family members said they were concerned that his assessment may have been influenced by his previous involvement.
Yes.
And Jubilant also expressed concern because, in his view, the responses of the DPP and Mr. Smith regarding the Norco Corner evidence in particular were contradictory.
So let's just recap. The Norco Corner is a corner in Bowraville around which 2 trucks drove, and they saw on the footpath a young man standing over the body of a young Indigenous man who was lying seemingly unconscious on the ground. And what both of them stopped and said, "Do you need a hand?" And the person standing said, I've called the police.
I'm just trying to help him.
And that was passed on to the police, and the police took a note of it, but didn't take statements from the drivers, and it didn't appear in the first trial and doesn't appear until the reinvestigation in the late 90s.
That's right.
Yeah.
And so Nick Cowdery had said that Norco Corner evidence was fresh but not compelling.
Oh, wow.
And Mr. Smith had determined the evidence was compelling but not fresh. And so Jubilant said he felt that it is quite a complex issue, but very concerning to have these 2 completely opposite conclusions drawn.
Yeah.
And sort of undermines.
Well, it's not uncommon that you have lawyers, including senior lawyers, who take the different view of the same question. And what you do in that case is you take it to the court and get the court to decide, and you get a ruling. Because, I mean, somebody's opinion.
But no one's willing to take it to
court. No, I know.
Court.
Well, that's the annoying thing.
Yeah.
The DPP should go, if, assuming Bar SC is an expert in criminal law, which I'm sure he was, faced with that, the DPP should go, well, I took a different view, but you know what? Let's get the court to sort it out.
So then what happened was December 2016, with Jubilant's persistence, so he's still going.
Is he still a police officer at this stage?
Yes.
Okay.
New South Wales Police submitted a new brief of evidence to the Director of Public Prosecutions, seeking to have the person of interest tried again for Clinton and Evelyn. They said it should be one trial. They should be run together.
Yeah.
And the Attorney General claimed that if the evidence relating to each of the disappearances and deaths of Clinton, Evelyn and Colleen was considered by a jury at a single trial, then that evidence would establish that each of the children were murdered, they were murdered by the same person, and that person was the person of interest.
Okay.
And that was through coincidence reasoning. So the Attorney General took it to the Court of Appeal.
So just to explain that, the only way, so the opinion seems to be that if all of the evidence in relation to Colleen's death, Evelyn's death, and Clinton's death was heard by a jury at the same time, that jury would conclude that there is no way to explain all of that evidence except that the person of interest was guilty of the 3 murders.
Yes.
Yep.
So now we're in 2018. The Court of Appeal are hearing it, and they said no.
So this is an application under the new legislation to re-prosecute.
Yes.
Under the fresh and compelling.
Yes.
Court of Appeal said no.
They noted that they had the discretion to order a retrial under the double jeopardy exceptions, but only if they were satisfied that there was fresh and compelling evidence and it was in the interest of justice. They came to the conclusion they could not be satisfied of that and the application must be dismissed. They did say, and this is a quote, "We acknowledge that the deaths of Colleen Walker, Evelyn Greenup and Clinton Speedy were tragedies for their families and the Bowraville community, and we recognise the distress that the deaths of these children and the subsequent investigations and proceedings have caused the families involved." But there was nothing they could do.
No.
So it was taken to the High Court.
Wow.
Yes.
Okay.
There was an application, made to the High Court in 2019.
For special leave to have the appeal heard?
Yes.
Failed.
Yeah, that's right.
Yeah.
Justice Kiefel, actually.
Kiefel,
said, "We can find no reason to doubt the correctness of the decision of the Court of Criminal Appeal," and said that it was not fresh evidence. That was the underlying reason. Yeah.
Because they have considered that fresh and compelling from one of the South Australian cases, I'm pretty sure.
It has been considered, yes.
Yeah.
I should ask Matthew to send in his research on this issue.
Yeah, that's right.
All right, so that's not the end though. In 2020,
okay, yeah.
The New South Wales Police Force announced that the reward that was currently in existence for information relating to the murders, which was $250,000,
wow,
was being increased to $1 million.
Wow.
For any information which led to the arrest and conviction.
Successful conviction.
Any person.
Just conviction.
Yes.
Yeah.
This was announced by Mark Speakman, who was the Attorney General of New South Wales at the time.
Got it.
And that was kind of in response to the fact that there'd been another push for some further reform to double jeopardy laws.
Oh, for God's sake.
And he said he couldn't see the utility in reforming it, that he didn't think that it would change the outcome for the Bowraville murders, and that it wasn't good policy to change laws for one particular case.
Yes.
And so he said all of that and then said, but let's increase the reward to $1 million.
Okay, there you go. Practical steps.
That's right. And then this year, just last month in October, there's been a bit of activity back in Bowraville. So there's been a revisiting by police to Bowraville to raise awareness again of the matters.
Yeah.
There is a real belief that someone knows something about Colleen, and that particularly Colleen's body not ever being found is something that they do hope to try and resolve.
So she's the 16-year-old who first goes missing.
Yes.
Okay.
And so they've said, the police said, finding Colleen's remains is absolutely critical in helping us close this painful chapter. And we are hopeful there are still people out there who have information.
Yeah. Well, yeah, I mean, that would be finding the body, then, I mean, its location then, would open up avenues of inquiry, no doubt, and cause of death if you can determine it from skeletal remains. I mean, look, I said there were problems with the police investigation, but if we're thinking about the fact that this is now 33, 34 years since those poor kids were murdered, there really has been progress in these cases consistently. They haven't actually been forgotten. No.
You wonder how it would have panned out if the investigation had started differently.
Yes.
We can't change that.
No.
But a couple of other things I wanted to take note of, because that was pretty much all I wanted to say then.
Yeah.
If anyone does know anything,
get in
please
touch.
contact Crime Stoppers. Or
That's probably better.
Yes.
I was going to say get in touch with this podcast, but probably better go to Crime
probably not
Stoppers.
us. Yeah, I'd go to Crime Stoppers. But I did find an article from May 2016. So this is before the Court of Appeal heard the final application for a retrial.
Okay.
And the person of interest, who was still able to be identified at that time, gave an interview to the ABC.
Wow.
And he said he would be open to a retrial so that he could clear his name.
Yeah.
He said he wants all the evidence to be heard together so that his name can be cleared, which is a pretty confident statement.
Very confident statement. Well, he's winning 2-0 at the moment, so.
So it was a podcast interview. And the interviewer said, would you welcome someone doing that, a court hearing all of this evidence at the same time? And the person of interest said, yeah, I've thought about that over the years since these double jeopardy laws have been changed. I've almost, if it wasn't for the strain it puts on the family emotionally and financially, the national celebrity that comes with it, I don't want none of that. But then again, I want the actual evidence to be all heard and seen that it wasn't me.
Wow. So the family, so he's 25 when this all takes place. He subsequently gets married, has children.
I think the families of the victims.
Oh, that's who he was referring
That's
to.
what I interpreted that as.
Does he still live in the area, in Bowraville?
I don't know.
Oh,
I don't know. I couldn't find where he is now.
Yeah.
All right. What else did I want to tell you? Some broader considerations from the case. The racial bias, I think, was definitely highlighted and discussed in depth in the parliamentary inquiry. Many of the family members expressed a firm belief that had the children been white, the investigation would have been taken more seriously. And Gary Jubilant also felt very strongly that race played a big part in the initial problems with the investigation.
And the coroner didn't make any recommendations about how police deal with, or how the police did deal with these?
I searched high and low for those coroner reports. Couldn't find them.
Wow.
And I'm pretty good at finding coroner reports.
Yeah.
So I don't know if they're not available, but literally not a thing that I could find.
Maybe because I named the person of interest.
I'm wondering if that is it. But there is stuff out there that has his name. Yeah. So I don't know. The other thing that I wanted to say was about some final thoughts.
Final thoughts,
yes. I'm just finishing it off with my musings.
Yes.
But I did, of course, think about other cases where children have gone missing and the difference in responses. And two that immediately sprang to mind were Cleo Smith from Western Australia and William Tyrrell, also New South Wales.
Yes.
So Cleo Smith, I don't know if you remember, that was 2021. She was 4 years old and she disappeared from a remote campsite in WA.
Wow.
She was phenomenally found 18 days later. So the guy who'd taken her wanted to keep her.
Oh, I remember this case. Okay. Didn't he have a doll collection or something? He was a bit of an odd bod.
Yes.
Yep. Okay.
And so that case just got immediate national coverage and attention and exposure. There was an immediate large-scale search. And thank God, because they found her safe and well.
Yes.
William Tyrrell, also a little 3-year-old white child, disappeared from his foster family's place.
Wearing a Spider-Man suit, wasn't he?
In a Spider-Man suit. And so that case received ongoing and intense media attention, publicity, searches, all of that sort of thing, appeals. And you compare that to the reaction to the missing kids in Bowraville, and there does seem to be a real gap. And then I thought, okay, well, maybe I'm being too harsh because Bowraville was in the 90s. Both of those examples were since the advent of, better technology and that sort of thing. And then I looked and I found a similar-ish case. And that was about a little girl called Samantha Knight from Bondi. She was 9 years old, a little gorgeous little white, pretty little girl.
Yeah.
She went missing in August of 1986, so similar years. And the reports that I found said that by the following day, thousands of volunteers had turned up to help search for her, and hundreds of thousands of missing posters were printed and shipped around the country. Her picture was stuck up on posters on power poles and shop windows across the city, and media outlets went into overdrive.
Yeah.
And that, I think, is a better example of that difference in response.
Yeah.
You know?
But again, not again, but that's in a big city, in Bondi.
Yes.
Presumably you're getting a better standard of policing when you roll up to the local police station.
Look, and I'm sorry. Not sorry, but to be fair, she wasn't found.
No.
Like, her killer was not identified until like 20 years later.
Wow.
He was already in custody.
And her body never been found?
No.
Oh, that's very sad.
I don't think so. And so I don't know. I thought we have to be conscious of this. And I think we're getting better, but I think there's still a lot of work to be done in terms of that racial divide. The other thing I wanted to say is just to finish off with Gary Jubelin. So I've talked about how he was so tenacious and so invested, and he did so much good work for this family. He was then placed on the William Tyrrell case.
Yes.
And that all went pear-shaped for him.
Eventually.
Because, again, that tenacity and that investment, it actually ended up.
They charged the wrong person, or?
Well, he used some improper practices for interviewing suspects and that sort of thing.
Okay.
And so he ended up being taken to court. He was removed from the William Tyrrell case.
Yes.
And then he was charged with illegally recording 4 conversations.
Yeah.
He was found guilty. He was fined $10,000 but avoided a custodial sentence. And
it's a pretty minor offence, recording conversations. And I think the law's different in New South Wales and Queensland. He probably would have got away with it in Queensland.
Oh, really?
Well, you can record a conversation you're a party to, even if the other person doesn't know.
As a police officer?
Well, I would have.
I don't think so.
Really? I'm not. Well, why would it be more onerous for a police officer than for a layperson? I know the recording requirements are different in New South Wales, and I understand that the police are more likely to prosecute.
Well, and I think there were consequences for the person who'd recorded illegally because things leaked and.
Yeah.
Anyway, but so he, the magistrate who sentenced him, acknowledged his distinguished career, but he emphasised the importance of adhering to legal procedures even in emotionally charged cases.
Yes, so especially in emotionally charged cases.
So I remember when that all happened, and I thought, gosh, that police officer was doing his best, and I feel sad that he left the police force after that. But
he hasn't looked back.
He hasn't looked back. He's written books.
One of our competitors.
The top crime podcaster in Australia, apparently.
Yeah.
But I think maybe there is something that the police force lost when he, resigned. I think he really was an example of a police officer who just is invested in justice for the victims. So I just wanted to acknowledge his hard work and where he is now.
Where he is now? Well, maybe we'll see if we can get him on the podcast.
Gary, contact us. We'd love to have you on the show.
Yeah.
But that's it, Joe.
Wow, what a roller coaster ride. Mostly down, actually. Sorry, there's not many ups in that story.
Well, there's not, because there's still no convictions.
Again, so we're leaving our listeners with no conclusion.
Well, I guess a resolution to do better.
Okay. There you go. You've heard it here.
Thanks, Joe.
Thanks, Lizzie. Thank you for listening to the episode. If you enjoyed it, please rate and review or like and subscribe. It all helps Lizzie and I keep this podcast going. If you're interested in clips, you can look at them on Instagram and TikTok. Just search for Justice Matters Pod. See you next episode.